Senator Butler.
Thank you, Mr. Chair, and thank you to all of the witnesses here. There's been so much here that really has grabbed my both imagination, source of incredible frustration, but also tapped into a number of experiences that I've had across my career. Professor Gillis, it's such a pleasure to hear you use the phrase collective action. As someone who spent 20 years in the labor movement, another tool that we have to give voice to workers is that of unionization. And in the space of unionization, there also is an arbitration process. There's an arbitration process that gives voice, Ms. Carlson, to the point that you made, that equalizes the voices and power of employers and employees through their chosen organizational representative or union. And every experience of union arbitration that I've had, there was a jointly chosen panel, not an association that gave you a set of names to consider. Every instance that a worker's grievance or case went through to arbitration, the union and the employer had to agree on who was going to be the arbitrator or panel of arbitrators. Everyone had strike ability to eliminate a name from that mutually chosen list. So I do believe that there is a framework here in terms of how we can utilize get the best benefits from arbitration, and we just have to look to some of the models that we have created. I am not here to say that that unionization is the only answer, but we do have models of fairness that we can call upon. Ms. Carlson, it struck me in your written testimony your reference to Tesla workers who have been, and a number of my colleagues have been working to support their unionization, their choice that they are making to choose to form a union there at Tesla. And we all know that there are certain categories of workers that today our labor laws don't allow to unionize. So as I was listening and reading the testimony, one of the things that I was curious about has been referenced here. You have been relentless. You have committed that you are not gonna quit. What are there are the category of workers that have available to them the tool of unionization. There's the category of workers who only by antiquated laws are traditionally excluded. What are some of the recommended evolved tools, new tools, contemporary tools that you would suggest that this committee, this Senate, really take up to advance the protection of human rights that you're so dedicated to?
Yes, so my strategy has been to try and take a bite out of the apple for each protected class because, as Senator Tillis mentioned, it has to be bipartisan, and it should be bipartisan because we're talking about human rights violations. So that has been the strategy. It's why I'm now moving forward with the Protecting Older Americans Act, and I support Senator Booker's bill as well about race discrimination and forced arbitration. But for me, giving workers choice and not being forced into arbitration is what this is all about. You suddenly give them the option of being able to have a voice. And trust me, a lot of them will not choose to speak it because I can tell you from personal experience, it ain't fun to come forward.
Yeah.
And as the professor has also spoken about this morning, it is very hard to prove your case. And so most of these cases are extremely relevant and sound if they actually get to court. And so that disproves the notion that we were going to suddenly have a flurry of cases when the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, I need to get the monogram or the acronym from you. Yeah, what do you call it? Okay, that's even harder. But anyway, it's a mouthful. So that's why I keep coming back to, if you give workers choice and their own liberty to make their own decisions, that to me is the fairest way to do this. And if you want to make arbitration an option, which it still is under the law, then they can choose it, but I wouldn't recommend it.
Yeah. One last question, Mr. Chair, if I could. Professor Gillis, you talked a lot in your testimony about how forced arbitration exacerbates economic inequality in the country. Another gift of the labor movement and unionization is greater pay equity. But it seems that in this space of forced arbitration, we continue to see those sort of, at least according to the data that you made reference to, greater economic inequality in the space. And so I'm curious. I just wanted to ask this really a question out of curiosity. I'm curious: is there any further information or greater detail that you can reveal for us about what the data shows relative to forced arbitration, particularly on women workers and workers of color, just to try to pair the two, the conversation or the response that Ms. Carlson just gave?
Of course, and I appreciate the question. Obviously, more data is always better, so we should do more studies. But the studies show us that women and minorities tend to work in fields where forced arbitration is employed far more often than other fields. So that's one good bit of evidence. I think we also have to take a sort of historical view, and there have been some studies that take a kind of a historical view. And the truth is that women and minorities are the least likely to bring claims in court, even before forced arbitration, right? The fear of retaliation, the intimidation that comes with being the person who's bringing the claim have often silenced women and minorities. And then I think we just have to be aware that, poor people in this country, they bump into the corners of our law in all sorts of ways. And those are sharp corners. And they don't necessarily know who to go to, how to get representation, how to get advice. And so many times they just end up lumping it, right? They can't afford to quit the job and find something else. And even if they did quit the job and find something else, everybody's doing it, Mom, right? Everybody's forcing you into arbitration. So I do think that, and I wrote this in my testimony, I mean, for those of us who are really concerned about the rising levels of inequality, forced arbitration is just one additional tool that enables that chasm to continue to grow.
Thank you. Thank you, Mr. Chair.